What up, peoples? Informatory Product back again with another informative video. Okay, this is not legal advice, and it's not intended to be legal advice. This is for your educational and research purposes only. If you need legal counseling, I suggest you seek one other than I. I reserve all of my rights, all rights reserved. Now let's get into this. Arraignment. Everything starts with the arraignment when you're dealing with the court or being charged. Okay, if I was to get pulled over for, let's say, a speeding ticket, and the officer issues me a ticket, on that ticket it's going to be my information, which I have given to him, and they're going to use that information against me. Okay, or if I don't give it to them, they could just get the information off of my license plate. However, they need the information. Okay, it's the only way they can charge you with an indictment. There's only two ways that they can charge you: indictment by information and indictment by grand jury. Okay, if there's no indictment by grand jury, then they'll assume there's information for them to indict you on. Okay, now arraignment. Procedure whereby the accused is brought before the court to plead to the criminal charge against him in the indictment or information. See that? Or information. The charge is read to him, and he is asked to plead guilty or not guilty, or, where permitted, no contender. Case law to back that up. Arraignment shall be conducted in open court and shall consist of reading the indictment or information. It's only one of the two: indictment or information. Grand jury or information that you have provided to the officer, the policy enforcer. Okay, arraignment shall be conducted in open court and shall consist of reading the indictment or information to the defendant, or stating to him the substance of the charge and calling on him to plead thereto. He shall be given a copy of the indictment or information before he is called upon to plead. Okay, simple. He shall be given a copy of the indictment. So if there is a injured man or woman, they should provide me with a copy of the indictment or information before I am called upon to plead. But if I have given him information, then he has a case against me. Okay, I didn't invoke my right to remain silent. Okay, further to prove that, let's go here. Information. Again, information. Okay, let's get into it. An accusation exhibited against a person for some criminal offense without an indictment. Okay, without an indictment, grand jury. An accusation in nature, an accusation in the nature of an indictment, from which it differs only in being presented by a competent public officer on his oath of office, instead of a grand jury on their oath. A written accusation made by a public prosecutor without the intervention of a grand jury. Okay, guys? Case law to back that up. Function of an information is to inform defendant of the nature of the charge made against him and the act constituting such charge, so that he could prepare for the trial and to prevent him from being tried again for the same offense. Okay, the function. Okay, this is how basically the modus operandi. Okay, the function of an information is to inform the defendant of the nature. So if you're in front of the judge and they ask you, or he or she asks you, do you understand the nature and the charge? And if you say yes, then you have provided them an indictment by information. You have waived your right for indictment by charge. Indictment by grand jury. Okay, you waived that right by accepting the charge, accepting the nature of the charge. Okay, at the same time, inadvertently, you're waiving your grand jury right to a grand jury trial. Okay, let's go on. While Fifth Amendment of U.S. Constitution requires federal government to prosecute infamous crime only upon presentment of a grand jury indictment, in most states, the information may be used in place of grand jury indictment to bring a person to trial. Okay? Simple, right? Let's prove this. Let's go here. I'm going to run through a couple of tabs here. I'm a little all over the place, but I'm going to give y'all two topics in one video, okay? It's going to be a surprise in the middle of this one, okay? I'm going to add the consumer finance laws, and I'm going to tie it to your information, okay? Waiver of indictment. Unless the offense is one which may be punished by death within the meaning of Federal Rule Criminal Procedure 7A, the defendant may waive the right to be indicted by a grand jury for any felony. Okay. Offense Rule 7B provides offense which may be punished by imprisonment for a term exceeding 1 year or at hard labor may be prosecuted by information if the defendant, after having been advised of the nature, after having been advised of the nature of the charge and of the rights of defendant, waives in open court prosecution by indictment. There it is, guys. When you accept the nature of the charge, when you understand the nature of the charge, inadvertently you waive in open court your prosecution by indictment, which is by grand jury. Okay? Further to prove that. Let's go. Okay? So whenever if you are indicted by information, you are indicted by the information in regards to being that corporation that the policy enforcer alleged that you was acting, in the capacity of. And to prove that, here it is. If the defendant is a corporation, it may ordinarily be prosecuted by information, since corporations are not amenable to imprisonment, but only a monetary penalty. Case law to back that up. You guys do your own research, do your own reading. Okay? Just get into where I need to go. Okay? However, in the absence of evidence showing that interstate or foreign commerce was affected, the prosecutor will have to prove there was an intent to do acts which, if completed, would have affected interstate or foreign commerce. Okay, guys? Simple. Let's go to the next tab. Governmental use. Identification documents. Okay? Your research. Governmental entity. Identification documents. Okay? A document made or issued by under the authority of a governmental entity, which, when completed with information concerning a particular individual, is of a type intended or commonly accepted for the purpose of identification of individuals. You see that, guys? Research. Admiralty claim. So, once you accept the nature of the charge, which is pursuant to information, you have accepted and agreed that it's an admiralty claim, okay, which will be the state, okay? 1. How designated. If a claim for relief is within the admiralty or maritime jurisdiction and also within the court's subject matter jurisdiction on some other grounds, the pleading may designate the claims as an admiralty or maritime claim for purpose of Rule 14C, 38E, and 82, and the supplemental rules for admiralty or maritime claims and asset forfeiture actions. Okay, guys? Do your research. It's an admiralty claim once you accept the nature of the charge. So basically, once you accept the nature of the charge, they throw you an onus. Okay? It's onus probandi. Do your research. Then you're going to have to prove that you are not guilty. Okay? You're innocent until proven guilty. But once you understand the nature of the charge, you become guilty until proven innocent. You become guilty until proven innocent. Okay? It's called onus probandi. Research. Person. In general usage, a human being, i.e. natural person, though by statute the term may include label organizations, partnership, associations, corporations. Okay? Organizations. Remember these words that I light up. Organizations. Okay? Corporation. An artificial person or legal entities. Remember these words. Created by or under the authority of the laws of a state. Okay? So they are created. Your corporation, your artificial person, your legal entity, your straw man, your driver's license is a creation by the state or of the state. Let's move on. Business corporation. So they put you in business corporation. Okay? Remember these words. Business corporation. Let's go. Business corporation. 2 words. 1. Okay? One form for the purpose of transacting business in the widest sense of that term, including not only trade and commerce, but manufacturing, mining, banking, insurance, transportation, and practically every form of commercial or industrial activity where the purpose of the organization is pecuniary profit, contrasted with religious, charitable, educational, and other like organizations, okay, which are sometimes grouped in the statutory law of a state under the general designation of corporations, not for profit. Excuse me. Okay, business. Remember that word, business. Employment. I'm going to go back to, where were we? Business corporation. Okay, where is it? Okay, business corporation. Employment corporation. Okay. Business, employment, occupation, profession, or commercial activity engaged in for gain or livelihood. You see that, guys? People. Research. Read. Organizations, as term is used in commercial law, includes a corporation, government or governmental subdivision or agency, business, trust, estate, trust, partnership, or association, 2 or more persons having a joint common interest, or any other legal or commercial entity, okay, or any other, okay, guys, any other, meaning everything else up here, it's a entity, okay. Let's move on. UCC, I believe. Okay. UCC 1-201 definitions. Okay. Organization means a person other than an individual. Okay, guys, this is where it gets tricky at right here. Organization means a person other than an individual. Person means an individual. Corporation, business, trust, estate, trust, partnership, limited liability company, association, so on and so on. Okay. Okay. When they're talking about a person, they're talking about an individual, corporation, business, trust, estate, and yada yada. However, when it's in regards to an organization, it means a person other than an individual. So when they're speaking, I use the word person, it doesn't include an individual, because an individual, it's separate from an organization. Okay? We're going to learn that in a minute. It's going to be very essential that you get that. Okay, we're going to move on. All right. Personal. Okay. Let's go. Business. Individual. As a noun, this term denotes a single person as distinguished from a group or class. And also, very commonly, a private or natural person as distinguished from a partnership, corporation, or association. But it is said that this restrictive signification is not necessarily inherent in the word, and that it may, in proper cases, include artificial persons. Okay? Okay, and as an adjective, individual means pertaining or belonging to or characteristic of one single person, either in opposition to a firm, association, or corporation, or considered in his relation thereto. Okay, remember that word, individual. Personal, appertaining to the person, belonging to an individual. Okay, belonging to an individual, personal. So if I wanted let's just say a consumer credit for personal, family, or household purposes, I would use personal. Okay, personal, appertaining to the person, belonging to an individual. So it will belong to either individual, limited to the person, having the nature or partaking of the qualities of human beings. Okay, of a movable property. Okay, personal. Okay, personal, relating or belonging to a single or particular person rather than to a group or an organization. Thought I'd throw in a different definition there. Government entity. The term government entity means an agency, instrumentality, or other entity of federal, state, or local government. Okay, guys? Instrumentality. Government entity means an agency. Okay, remember those words. All right, it's where I get tricky at. If you was to use your driver's license to identify yourself, to partake in a credit transaction, it actually takes you out of a natural person status and puts you in a business status or organizational status. Okay. The reason why they do that is because they're running away from Regulation Z. Okay. See, the Father, with God, nothing is hidden. And the one gift that was given to us as humans, as man and woman, is that we can get truth from combining logic and reasoning together. Okay, if you have reason, you combine it with logic, you either get your truth indirectly or directly. Okay, that's a gift we all should be able to exercise. Okay, let's get into this. Business, commercial, agriculture, or organizational credit. Okay, this will be exempt transaction. Okay, basically, if a consumer credit is extended to a consumer, then there's a right to rescind. Okay, if it is made to an organization or business or commercial or agriculture purpose, then it is exempt, meaning that there is no right to rescind the security interest. Okay, so this is why See, once you get reason and you get your why, then you create your logic. So the question is, why are they running away from Regulation Z? So I have to go dig, and I'm about to show you guys why are they running away, or why they're trying to avoid Regulation Z in all possible ways. Okay, the following transactions are not subject to this part, or if the exemption is limited to specified provisions of this part, are not subject to those provisions. Okay, A, business, commercial, agriculture, or organizational credit. Okay, an extension of credit primarily for a business, commercial, or agriculture purpose. An extension of credit to other than a natural person, including credit to government agencies or instrumentalities. Okay, that's that driver's license. Okay, agencies will be a financial institution. Okay, again, an extension of credit to other than a natural person. Okay, that means any credit that's extended to any business, anybody other than a natural person, is exempt. What I mean by exempt, meaning that they do not have to give us the right to rescission notice. Okay, if they was to give us the right to rescission notice, we will rescind the security interest and only pay on an obligation and not the interest. The interest is what's killing us. There is no value in ownership. It's only value in interest. Okay, if you have ownership interest, then that's the value. Okay, check it out. Primary purpose. A creditor must determine in each case if the transaction is primarily for an exempt purpose. If some question exists as to the primary purpose for a credit extension, the creditor is, of course, free to make the disclosure, and the fact that disclosures are made under such circumstances is not controlling on the questions of whether the transaction was exempt. Okay, see comment 3A-2, -2, however, with respect to credit cards. Business purposes, okay? I'm going to keep going. Y'all do the reading. I'm going to where I need to go. Okay. Organizational credit. The exemption for transaction in which the borrower is not a natural person. See that? The exemption for transaction in which the borrower is not a natural person applies. For example, to loans to who? Corporations, partnerships, associations, church, unions, and fraternal organizations. Okay, the exemption applies regardless of the purpose of the credit extension and regardless of the fact that a natural person may guarantee or provide security for the credit. You see that? However, credit is extended for consumer purposes to certain trusts and consideration is considered to be credit extended to a natural person rather than credit extended to who? An organization. Okay, specifically for who? You do your own reading, guys. Just showing you guys where it is. It gets juicy. Next tab. Okay, under Regulation Z, person means a natural person or an organization, including, yeah, that's right. Under Regulation Z means a natural person. Then why do we not access the natural person credit, which will be named consumer credit? Okay, consumer credit has a right of rescission. Okay, again, consumer credit has a right of rescission. Now we'll show you guys that in a minute. Organizational credit. Okay, I went through that. Okay, when you're dealing with a 1003 form, it's an open-end line of credit. Okay, but this is why they're using the open-end line of credit opposed to the closed-end line of credit. It is an open-end credit plan. Okay, Open end line of credit means an extension of credit that is an open end credit plan defined in Regulation Z, 12 CFR 1026.2A20, but without regards to whether the credit is consumer credit as defined in 1026. Okay, guys, consumer credit. Okay, let's define it. Let's hit 1026. See, let's find out what consumer credit is. Consumer credit means credit offered or extended to a consumer primarily for personal, look at that word again, family or household purposes. Consumer credit, okay? But they take us out of consumer credit status, put us in organizational status, okay? And they can do that without regards to whether the credit is consumer credit if they use the open end line of credit opposed to the closed end line of credit. Okay. Person means a natural person or an organization. Okay. All right, let's go here. Regulation M, when it comes to consumer leases, organization or other entity. A consumer lease does not include a lease made to an organization such as a corporation or a government agency or instrumentality. Okay. Driver's license. All right. Such a lease is not covered by the regulation, even if the lease property is used by an employee, for example, primarily for personal, family, or household purposes, or is guaranteed by or subsequently assigned to a natural person. Okay, guys, look at this. Such a lease is not covered by the regulation, even if the lease property is used by an employee. The driver license will be an employee. You will be a driver. Okay, even though if you use it, take it home and use that motor vehicle for primarily for personal, family, whole house purposes, or is guaranteed or by or subsequently assigned to a natural person. Doesn't matter. They put you in organizational. They created you as an organizational entity, if you will. All right, move on. All right. So when there is a, if there was a consumer credit and you had a mortgage based on a closed-end transaction that had a right to rescission, right of rescission, right? Then therefore you will be able to rescind if they try to foreclose on your house. Okay. Regulation Z. This is why they're running from Regulation Z, because we have a right of rescission. And I'm going to show you what it does. Section 1026.23H, just here, special rules for foreclosures, applies only to transactions that are subject to rescission under 1026.23A1. Okay, let's go there. Let's go to that one. All right, 1026A1. Consumer's right to rescind. Okay, this is Regulation Z. Consumer's right to rescind in a credit transaction in which a security interest is or will be retained or acquired in a consumer's principal dwelling. Each consumer whose ownership interest is or will be subject to the security interest shall have the right to rescind the transaction, except for transaction described in paragraph F, okay, of this section. For purposes of this section, the addition to an existing obligation of a security interest in a consumer's principal dwelling in a transaction. The right of rescission applies only to the addition of the security interest and not the existing obligation. The creditor shall deliver the notice required by paragraph B of this section, but need not deliver new material disclosure. Delivery of the required notice shall begin the rescission period. Okay? You have a right to rescind the interest. Anybody that has a mortgage would know that they're paying a lot of money on interest, and their principal is maybe $100. It's crazy. Okay, let's move on. General character of an instrumentality of interstate commerce. I just want to prove to people that your driver's license is an instrumentality. Okay, general character of an instrumentality of interstate commerce. An instrumentality of interstate commerce need not stretch across state lines, but may operate within a particular state as a link in a chain or system of conduits through which interstate commerce moves. Obvious example of such facilities are railroad terminals, airports, which are components of a system of air transportation, bridges, and canals. A facility may be used for both interstate and interstate, but when it is so used, it is nonetheless an interstate instrumentality. Okay, such double uses does not exclude construction employees from being engaged in commerce. Okay, let's see where I needed to go. Okay. I believe I'm in the wrong tab. Okay, the wrong tab, I believe. By a city of employees. Okay, employment. Okay, service performed after 1954. Basically, this is to say who's our employees and who's not. Okay, by a city of the United States as an employee for an American employer. Okay, service performed after 1954 outside the United States by a citizen of the United States as an employee for an American employer constitutes employment provided the services are not specifically accepted under Section 3121B. For definition of citizens of the United States and American employer, see and respectively. Okay. Citizens of the United States, that would be a United States citizen. Okay. An American employer. Okay, we're gonna find out what are these definitions. Okay, state, United States, and citizen. When used in the regulation in this subpart, the term state includes the District of Columbia, the Commonwealth of Puerto Rico, the Virgin Islands, yada 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 yada. Okay, when used in the regulation in this subpart, the term United States, when used in a geographical sense, means the several states, okay, including the territories of Alaska and Hawaii before their admission as states, before their admission as states. The District of Columbia, the Commonwealth of Puerto Rico, and the Virgin Islands. When used in the regulation in this subpart with respect to services performed after 1960, the term United States also includes Guam, American Samoa, when the term is used in a geographical sense. Okay? The term citizen of the United States includes a citizen of Commonwealth of Puerto Rico or the Virgin Islands, and effective January 1st, 1961, a citizen of Guam or American Samoa. Okay, include, you can always replace that word with involve. Okay, the term citizen of the United States involves a citizen of Commonwealth of Puerto Rico or the Virgin Islands. Okay, citizen of the United States. Let's go on. Who is American employer? The term American employer means an employer in which the United States or any instrumentality thereof. So if you have a driver's license, the United States is your employer. Okay? They are your employer. You are actually a driver, a motor carrier. Okay, you are a corporation organized under the laws of the United States. All right. All right. Services performed within the United States. So if the policy officer can prove that you was performing a service, and by that I mean once you give them your driver license, you have literally proved and given information that you was performing a service within the United States. Okay, here's the proof. Service being performed within the United States. Service performed after 1954 within the United States by an employee for his employer, unless specifically accepted by section 3121B, constitutes employment. Okay. With respect to services performed within the United States, the place where the place where the contract of service is entered into is immaterial. The citizenship or residence of the employee or of the employer also is immaterial, except to the extent provided in any specific exception from the employment. Thus, the employment and the employer may be citizens and residents of a foreign country, and the contract of service may be entered into in a foreign country, and yet if the employee under such contract performs services within the United States, there may be to that extent employment. Okay? Let's move on. Okay? 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are what? Citizens of the United States. And where would you see that at? So basically, I'm saying we're 14th Amendment persons. Huh. Gotcha. But if that's the case, let's go back. If that's the case, the term citizen of the United States involve a citizen of the Commonwealth of Puerto Rico or the Virgin Islands. If that would be the case, it's interesting. Just seeing that. All right, let's go here. Okay, the HMR are found in Title 49, Code of Federal Regulations, Part 100 through 185. As provided in 171.1, the HMR apply to any department, agency, or instrumentality that transport or causes to be transported or shipped hazardous material interstate, interstate, and foreign commerce by all modes of transportation. Get that? Instrumentality. Okay. Hazardous material. Okay. All right. I want to show you guys something. Where is that at? Okay. 41 CFR official use of government motor vehicles. All right, let's go. Let's see what this say. Official use of a government motor vehicle is using a government motor vehicle to perform your agency's mission as authorized by your agency. Government motor vehicle means any motor vehicle that the government owns or leases. This includes motor vehicle obtained through purchase, excess, forfeiture, commercial lease, or GSA fleet lease. Okay? Okay. Go on here. Okay, where is it? All right. Let's go to who are employees. Okay, guys. Who are employees? This is amazing. This is why I like to stay under common law jurisdiction. You guys about to learn why I'm heavy on common law rules and jurisdictions. Okay? Who are employees? In general, whether an individual is an employee with respect to services performed after 1954 is determined in accordance with Section 3121D and O and the Section 3506. Okay? Do your own research. I'm going where I need to go. Okay, corporate officers. Okay? Generally, an officer of a corporation is an employee of the corporation. However, an officer of a corporation who has such does not perform any service or performs only minor services and who neither receive nor entitled to receive directly or indirectly any remunerations is considered to be an employee of the corporation. A director of a corporation in his capacity as such is not an employee of the corporation. Okay, guys? You see that? However, an officer of a corporation who has such does not perform any services or performs only minor services and who neither receives nor is entitled to receive directly or indirectly any payment in consideration and is considered not to be an employee. So if I'm not getting paid, why will I identify myself as a corporate officer, which will be a carrier? Motor carrier is a corporate officer because you're under your official capacity. Okay. You are under your official capacity. Common law, employees. This is what I stand under. Okay. Every individual is an employee if under the usual common law rules the relationship between him and the person for whom he performs services is the legal relationship of employer-employee. Okay? So if I'm a common law employee, right, and under the usual common law rules, the relationship between him and me, or me and the person for whom I perform service for, we have a legal relationship of employer-employee, being that, I'm under contract, okay, conscionable contract, okay. So let's skip on, let's keep going. Generally, such relationship exists when the person for whom services are performed has the right to control and direct the individual who performs the service, not only as to the result to be accomplished by the work, but also as to the details and the means by which that result is accomplished. That is, an employee is subject to the will and control of the employer, not only as to what shall be done, but how it shall be done. So basically, if I'm a common law employee and I hold myself out as a public motor carrier or common motor carrier, okay, I am subject to the will and control of my employer, which would be who? The United States. Not only as to what shall be done, but how I shall do it. Okay. In this connection, it is not necessarily that the employer actually direct or control the manner in which the services are performed. It is sufficient if he has the right to do so. The right to discharge is also important factors indicating that the person possessing that right is an employer. Okay. Other factors, characteristics of an employer, but not necessarily present in every case, are the furnishing of tools and the furnishing of a place to work to the individual who performs the service. In general, if an individual is subject to the control or direction of another merely as to the result to be accomplished by the work and not as to the means and methods for accomplishing the result, he is an independent contractor. Okay, you guys keep reading on. Okay. You guys do your homework. But that's all I have for now. I didn't mean to make this video long, but I had a few tabs to just go through to give y'all a little something, you know, a little spark to ignite your fire. Okay, guys, that's all I'm gonna do. You know, I hope this is enough information to start your own puzzle. I gave you a little, you know, a couple of pieces. So I hope you guys will be able to find your other pieces. And if, you know, I missed something, somebody let me know. You know, we can work on this together. But yeah, that's it.